that very overground? But it's very overground, you're a conviction, but you know, you've got to get to that. What are you asking the search? You have to go over.
She doesn't think it'd be relevant to today's hearings, but
we're not filing on
this time,
But without her, who knows?
We're not filing the affidavit. We're not filing the affidavit.
yeah.
Yeah, but that's good. They're certainly known to each other, but not domestic. I'm not going to oppose being surrendered this one. I think it's your part to ask the court all the time. They did say 5 years.
Mine looks like those. Oh, yeah, don't worry, we're going to call Mr. Lohan next.
You're on before me,
no, so when you're ready, no worries. That's okay.
We've got a second prosecutor.
Sorry.
Oh, no.
Carrying on.
She's not ready yet. We don't know she's a partner.
Oh, so who's that, sorry?
The victim in his home.
Oh, right. Cheers, Michael.
Oh, there's a room about Heathrow. Someone said something about Heathrow. What?
Yeah, we haven't got the weeks yet.
He's going to go up and say, basically, I'm a Mackenzie friend.
Carry on. I'm sorry, madam, I think you're being told that you can't approach the dock or the dock officer. So, silence in court, standing.
In front of the door.
You're standing, please, sir. If you can't stand, you leave.
Sorry, I was just
no, gentlemen, sitting down. Thank you.
Thank you.
Thank you. Don't make a fuss.
Thank you. I'm afraid we haven't called your case on yet. So I don't know who you are because we haven't called your case on yet.
You're a clerk, are you?
I am, yeah.
Your worship, the next case to be called on the list is the case of Mr. Dominic Lohan, here unrepresented in custody.
Thank you, Mr. Lohan. Could you give the court your full name and date of birth, please?
Are you addressing me?
Yes, please.
Then I'll grant you courtesy there, but I'm here as a friend of the court. I believe there's been a mistake. I wish to seek remedy in the way of notice.
I have no idea what that means, but what can I call you, please, for the purpose of today's
If you like,
hearing?
you can call me friend if you like.
Friend, thank you. Do you have a date of birth, please?
What is the date of birth?
The date on which you were born.
Is it not the date that you're registered to be born?
No.
So it's not the date that's on the birth certificate?
Friend, can I ask you, please, for your date of birth?
And what about the date that's on the birth certificate, or what my mother told me?
I think Mr. Lowe has declined to give that.
Yeah, County Fund. Do you want me to go in?
10th of November, facing three matters. Section Class B drugs, failure to provide a sample to test for Class A drugs, and threatening behaviour. Understand, friend, that you're unrepresented today and you're representing yourself. Is that right?
I cannot make any comments on this. I've still not received the full bundle, including witness statements and technical records.
What's been served? What was served yesterday, please? Friend, were you served with any paperwork
Yesterday I was served nothing.
No.
So the information what I can gather from this file is simply the prosecutor who was here has mentioned his list the same, and advance information according to the file has been served, whether it has been served upon both the gentleman, Mr. Edwards, as well as Mr. I cannot see from this file, so perhaps my colleague can see on this.
So the position is this morning, the duty says that it was made very clear that it didn't want her to act for her, but she took the papers, put them down the cells. It was only when the cells were allowed to show the CCTV that I gave this call at the CCTV to put it down on the court laptop to be in the cells. I understand he's watched the CCTV.
Do you know what happened to the paperwork?
Straight to him.
Right, so you've had statements
I've not had
and a
the full
summary.
bundle, including the
You're not
technical records.
entitled to that at this stage. You're entitled to only to a summary of the case.
So
I'll move to asking your pleas. So, friend, first of all, it said that on the 9th of June 2011 at St Paul's Churchyard in the City of London, you had in your possession a quantity of cannabis, a controlled drug of Class B. To that matter, you have three choices. You can decide to indicate a plea of guilty, indicate a plea of not guilty, or you can give no indication of guilty at all. If you, you're not entitled to it at this stage, as I've
who would be entitled?
This is it, no.
Who would?
And so, if you decide to indicate a plea of guilty, this court can either sentence you to death, or you can be sentenced to the Crown Court if this court felt its powers weren't enough. If you decide to indicate not guilty or give no indication at all, this court will hear a little bit more about where best to deal with it. And that's either here at the Magistrates Court or at the Crown. Before you decide that, if you're tried at this court and found guilty, or you later change your plea to guilty, you could still be sentenced at the Crown Court if this court felt that its powers of punishment weren't enough. Do you understand all of that, first of all?
I do not understand, because understanding legalese means to stay under your jurisdiction.
I'm afraid that's completely irrelevant at this stage, Mr. Lowe. Do you wish to enter a plea at this stage?
The thing is, how can I make a plea?
Guilty, not guilty, or no indication? You don't have to give an indication if you don't want to, but obviously I need to explain to you about the prejudice of pleading guilty, etc.
How can I make a plea of being guilty to the facts without having the facts presented to me?
Do you wish to plead not guilty then and have the facts read to you at a trial?
The thing is, I need the facts presented to me.
I'm afraid that's not going to happen today, sir. As I say, if you want to have a trial, then the allegations, because they're not facts until they're proven, of course, the allegations would be put at any trial. So, would you like to, as I say, it's either guilty, not guilty, or no indication at this stage?
Well, only the defendant makes a plea, is that correct?
That's right. Yeah. So, can I ask you for the final time, guilty, not guilty, or no indication?
No indication.
Get out of here.
There's no defendant in public gallery. As you just stated, only the defendant will enter a plea.
I'm afraid, friend, that you're here and you've been charged with an allegation that makes you a defendant. So I'm afraid I have to ask.
Do you have any proof that I am the defendant?
Yes, I'm afraid you were live scanned yesterday and your fingerprints
This
match
is
your
why I need a custody
identity.
record, because I saw with my own eyes it come back as unknown.
Friend, again, if you don't wish to indicate a plea, one will be entered for you on behalf of the court. Do you want your chance to give a plea?
Well, as you already stated, only the defendant pleads. So whoever enters that plea is the defendant.
That's not correct, of course, is it?
Well, you just stated that, did you not? I think you may have done.
You are the defendant, friend. That's what I'm saying to you.
It is your opportunity to say one of those things. If you choose not to entitled to, then we will take an implication.
I don't see what proof there is that I'm liable for these offences.
Well, we're not dealing with
Well,
proof
that's
at the moment.
the
We're not
point
dealing
of
with
it.
proof in this courtroom.
Not right now, not today we're not, no. That will be at the trial. That's the way it works.
Doesn't matter
Well,
what.
as you've said, only the defendant went to the plea.
Would you like to do that? No, you won't.
So, as I say, it's said that on the 9th of November 2011 at St Paul's Churchyard in the street, you had in your possession a quantity of cannabis, a controlled drug of Class B. As I stated, guilty, not guilty, or no indication, please.
As you said earlier, just to remind you,
I'll
you
take that as
said
a refusal to
only
enter
the
a plea.
defendant knew.
What?
Oh, fuck.
Silence, please.
I have to ask for silence in the public gathering so we can make progress. No, it's not progress.
So I'll put the other two matters then, sir. So the next matter is, it said that on the 9th of November 2011 at Bishopsgate Police Station in the City of London, being a person in police detention arrested for, and at the time the requirement was made, had not been charged with the court possession of a Class A drug contained within Schedule 6 of the Criminal Justice and Court Services Act 2000, he failed without being long in whether you have a Class A drug in your body, guilty or not guilty.
Only the defendant makes a plea, you just stated.
Thank you. Finally, on the 9th of November 2011 at St Paul's Churchyard in the City of London, used towards Mark Edwards, threatening, abusive or insulting words or behaviour with intent to cause that person to believe that immediate unlawful violence would be used against him by any person, or to provoke the immediate use of unlawful violence by him, whereby that person was likely to believe that such violence would be used, or that such violence would be used. Guilty or not guilty?
I'd like to remind you of your statement where you said only the defendant knew.
Thank you, friend. So, sir, it falls to the court to enter not guilty pleas on behalf of this defendant. And if I could ask you to deem that as such.
We don't deem that as just outlined.
Thank you. So can we, if perhaps, friend, if you take a seat for a moment, we'll deal with mode of trial on the cannabis matter.
So the not guilty pleas have been entered for all
Do you
three,
want to take a seat for a moment, friend?
all three matters.
Right.
So the prosecution will say that the matter in respect of the drug matter, it is suitable for summary trial. The brief outline of the allegation being that on 9th of November 2011, 1:45 a.m., after an altercation took place, the police searched Mr. Lohan and he was found to be in possession of a small plastic bag containing crushed leaf-like substance. That was Class B drug, sir, and the prosecution will say that this is a small amount consistent with person who is suitable and has sufficient sentence.
Very great.
Thank you. So, friend, as I've stated, you have the right to be tried by judge and jury at the Crown Court, or you can choose to be tried at this court. Before you decide, you must understand if you're tried at this court and found guilty, or you later change your plea to guilty, that you can still be sentenced at the Crown Court if this court to feel its house punishment weren't enough. Where would you like any trial, here or at the Crown Court with judge and jury?
Confirm or deny it, only the defendant will make that decision.
I can't. It's for you to give it. To appear before it. Well, so if friend doesn't consent to summary trial, it will have to be before the Crown Court. I'm afraid that's how it would be. So, again, would you like to consent to a trial at the Magistrates' Court, or would you like to have your trial before the judge and jury at Crown Court?
Could you confirm or deny it for me? Is it only the defendant that makes that decision?
Thank you very much. So, sir, as I say, I think it would have to be the Crown Court, the judge and jury. I would need consent for a summary trial, and that's not forthcoming, so...
We'll have to go to the Crown Court to be judged.
So, sir, we're working now towards a date for committing. Yes, I suppose it would be for that little hearing. Friend appears before you today in custody. I don't know if you have an application for bail. Friend? Okay. Well, whether there's any objections from the prosecution as to whether you're granted bail or not, then the court will say about bail.
So the prosecution opposes bail. There are substantial possibilities that Mr. Lohan will fail to surrender. Or obstructive course of justice. Before I give you the grounds of proposal bail, sir, if I may give you the brief outline of the allegation. Yes, on the 9th of November 2011, this was 1:45 a.m. The offence took place at St. Paul's Cathedral, where a male was engaged in a heated discussion with a female protester from the camp. The co-defendant, Mr. Edwards, came to me as the male was becoming aggressive. The co-defendant, Mr. Edwards, used both of his hands and shoved the male forcibly away. That male returned, and Mr. Edwards had to be separated from him. After the co-defendant, Mr. Edwards, had moved away from the male, Mr. Lohan then approached. He approached the co-defendant, Mr. Edwards, and shoved Mr. Edwards further away with both of his hands. Mr. Edwards, the co-defendant, received 2 blows to the side of his head, causing slight swelling and discomfort, which was caused by Mr. Lohan and his pain. Mr. Edwards then grabbed Mr. Lohan, and then police arrived, sir. Mr. Lohan was arrested, and as I said, he was found to be in possession of Class B drugs, which was a substance at the police station with the drug, sir, and he was arrested after in the interview. Mr. Lohan was asked questions. Was in battle pain with a broken handle. He said he got broken when the co-defendant threw it in the lake, and that is when it became broken. He said that he had no need for it, but he liked to have it with him. And also in respect of the herbal substance, he said that it was not his. He was holding it. Those are the facts in this case. So far as the grounds of proposal bail are concerned, so I'll hand up the previous convictions list. I understand Mr. Lohan has seen it.
I don't know. When we've seen, yeah, we've seen that this morning. I think it's being confirmed that you have.
What does that have to do with me now?
The court now has to make a decision.
All this evidence that I need from...
The court now has to make a decision on as to your bail, whether you're released before committal for trial or whether you are kept in custody, and previous convictions are relevant to that consideration for the bench.
I'm sure that I will be turning up to court because the video evidence is quite clear. I looked at it against
I'm sorry, please, can you start that again?
The video evidence is quite clear what actually happened in that instance, and I will really turn up to the court and stand there and be honest.
I'm not sure the Crown have finished for the moment, but I will ask you in a second. Can the prosecutor actually finish? Sorry?
No, I have to see my justice again.
Can we just read through the previous conviction?
Have you broke bail before? Have you broke bail before?
looking at the front of the meeting about failing to surrender, there's only one recent failing to surrender in January this year. The other
Yes, sir. If I may borrow the list, sir, I'll give my objections accordingly.
May I,
So you'll have your opportunity in a minute. What are they you'll say?
So as you have looked at the previous convictions list, Mr. Lohan has got previous convictions. He has a number of previous convictions, including cautions. He has 19 previous convictions, and his last conviction being on 21st of March 2011 at Ealing Magistrates Court, whereby he received 14 days imprisonment for and that offence was committed once on bail, sir. And as you have looked, Mr. Lohan has also got alias, 2 alias names, and he has got 3 alias date of birth. He has been convicted for 18 offences. He has been convicted on the 19 occasions for 42 offences, sir. And out of those 42 offences, 3 offences are against the person, and also there are 14 drug-related offences, sir. He's a offending factor, and also, sir, he has, as we have said, that he has got a previous conviction for failing to surrender. He has 6 previous convictions for failing to surrender, and one of them has been very recent, sir. He has committed 4 offences whilst being on bail, and he has also breached one of the court orders, sir. The prosecution will say that when the police spoke to him, when we arrested him, he did not provide an address. He denied in the interview that he was residing at his tent at the fortress camp at St. John's Cathedral, although he was residing there. And also, sir, the prosecution will say that if Mr. Lohan is released, he may return to the fortress camp and or at St. Paul's and interview witnesses or the co-defendants in this matter, sir, and that he will take further offences. So those are my objections to the
Bail conditions.
I'll give you the opportunity to speak. Can I just say before I do you're right to have bail. What the prosecution is saying is because of your history of offending and the nature of your offending, they're worried that you will interfere with witnesses, ultimately further offences, or fail to surrender to bail. If you want to answer those questions, this is now your opportunity to do so.
I've never put any witnesses, and I don't intend to. The only one that's recent on failing to surrender was turned up to court, and my ex-partner asked the judge to honour their oath, and the judge went out of court and served a warrant failing to appear. We were arrested outside the courtroom. So it was lack of knowledge of procedure in the courtroom.
On your part?
Yes, definitely. And basically, I want to stand up honourably.
I have no.
The thing is, I was strangled. I've raised my arms up. I don't know if you've ever been knocked out. As I'm getting knocked out, I've raised my arms up. I'm carrying a cane. Cane and thrown in the road and had a big gash on it. If I hit the man with it, it would have been gashed over his body. You should have it in the evidence.
I don't want to stop you a mid-flow, because I understand what you're saying, but you may want to use this later. What I want you to say to me is why